So, right here, I am not going to say that you're wrong in every instance. That's not what I'm saying, so don't misconstrue it, please. So, right now, I did a search, all state, all federal. When a creditor uses a tow company or similar entity to repossess a vehicle, the legal determination of whether the tow company acts as an agent for the creditor depends on the specific facts and circumstances of the relationship between the parties. Courts have addressed this issue in various contexts, often focusing on the level of control the creditor exercises over the tow company and whether the tow company is considered an independent contractor or an agent. There are times they might be considered as an independent contractor, which would be they are not an agent. Okay. In McGrady versus Nissan Motor Acceptance Court, the court held that a repossession company acted as an agent of the creditor for the purpose of repossessing a vehicle. The Alabama Supreme Court emphasized that a secured creditor's duty under UCC 7-9-503 is non-delegable, meaning the creditor cannot delegate liability for breaches of peace during repossession. Since the repossession company is acting as agent, the principal holds all the liability. This suggests that in some cases a tow company may be considered an agent of the creditor, particularly when the creditor retains control over the repossession process or the tow company acts directly on behalf of the creditor. Well, that can be determined, one, by the documentation the tow company received. Because in my situation, I found out they actually have message boards, for a loose term, where they post the information and the documentation. Conversely, in Nicholas versus Metropolitan Bank, the court found that a repossession company was an independent contractor. So in that case, they were. Okay. Now this is all state, all federal. So, when does the tow company act as agent and when do they not? A tow company acts as an agent for creditor in vehicle repossession cases when it is authorized to act on behalf of the creditor. Most of the time, they will announce that they are doing it on behalf of the creditor. And their documentation shows that. Under agency principles, a tow company may act as an agent for a creditor if it is authorized to act on the creditor's behalf and exercise control over the repossession process. For example, in Equalease Corp versus Neff Towing Services, the court found that a repossession specialist acted as a sub-agent of the creditor's lawyer, and the towing company engaged by the repossession specialist was bound by the creditor's authority. Similarly, in McGrady versus Nissan, the court held that a repossession company was an agent of the creditor for the purpose of repossessing a vehicle, emphasizing that the creditor's statutory duty to avoid breaches of the peace during repossession was non-delegable. So, when I tell you that they act as agent, primarily they do. There are instances, yes, where they may not.